It's high time we call out the judiciary for their egregious failures in upholding the Constitution, the very document meant to shield the people from tyrannical overreach. For decades, judges have allowed unconstitutional doctrines and rulings to fester, prioritizing bureaucratic convenience or political expediency over the rights of everyday Americans. These aren't mere oversights, they're betrayals of integrity, where black-robed elites abdicate their duty to protect the vulnerable, letting harmful precedents stand and inflict real damage on lives, liberties, and livelihoods. Let's dive deeper into this judicial rot. We'll explore key examples of judge-made laws that lacked any constitutional basis, how they've harmed the people they're supposed to protect, and why judges' lack of spine in overruling them sooner is a crisis of integrity. Stick around till the end for what we can do about it. First up, the Chevron deference doctrine, born in 1984 from the case Chevron U.S. A. Incorporated v. Natural Resources Defense Council. This wasn't pulled from the Constitution or any law passed by Congress, it was a pure judicial invention. Courts were told to defer to federal agencies' interpretations of ambiguous statutes, effectively handing legislative power to unelected bureaucrats. This violated the core separation of powers in our founding document. For 40 years, this allowed agencies to overregulate everything from fishing boats to environmental standards, crushing small businesses and individual freedoms. Remember the fishermen and Loper Bright Enterprises v. Raimondo? They were forced to foot the bill for government monitors on their vessels, all thanks to agency overreach that courts just rubber-stamped. It wasn't until June 2024 that the Supreme Court finally overruled it in a 6-3 decision, declaring that judges, not agencies, must interpret the law. But ask yourself, why did it take 4 decades? Where was the judicial courage? This delay let government bloat harm millions, proving judges too often lack the integrity to act swiftly. Next, qualified immunity, another court-created doctrine with zero roots in the Constitution or the Civil Rights Act of 1871 it's supposedly based on. This legal shield lets government officials, especially cops, dodge accountability for violating your rights unless the violation matches a near-identical prior case. It's a free pass for misconduct, illegal searches, excessive force, even shootings of unarmed people. Victims get no justice, while trust in the system erodes. As of January 2026, federal qualified immunity remains intact, despite stalled reforms like the George Floyd Justice in Policing Act. Some states are fighting back. Colorado, Montana, Nevada, and New Mexico have banned it in state courts, and others like California are chipping away with laws tying it to things like mask wearing by officers. But federally? Judges keep this zombie alive, harming the very communities the Constitution protects. History is full of these failures. Plessy v. Ferguson in 1896 invented separate but equal, blatantly violating the 14th Amendment's equal protection. It enabled Jim Crow segregation for 58 years, oppressing black Americans in education, voting, and daily life, until Brown v. Board of Education overruled it in 1954. Or Korematsu v. United States in 1944, upholding the internment of Japanese Americans during World War II, a due process nightmare. It wasn't formally overruled until 2018, but its discriminatory legacy poisoned policies for decades. These weren't just rulings, they were unconstitutional case law allowed to stand, causing generational harm because judges lacked the guts to challenge them. Fast forward to today, January 2026. The Supreme Court's 2025 to 2026 term is eyeing more precedents, like potentially overruling Humphrey's executor from 1935, which protected independent agencies from presidential whims. The court has been ditching old rulings left and right, Roe in 2022, affirmative action in 2023, but critics say it's selective, often favoring power over people. Recent years have seen mounting criticisms of judicial integrity. Retired judges warn of threats to independence amid partisan attacks. Others blast the Roberts Court for sanewashing, distorting reality in decisions that disrupt law and democracy. And Chief Justice Roberts himself defended the system in his 2024 year-end report, invoking civil rights-era heroes while dodging accountability for an imperial court. Judges swear to uphold the Constitution, Yet too many defer to bad precedent or politics, enabling tyranny. This is an oversight, it's a betrayal. So, what now? Demand judicial reform, term limits, ethics codes, ending lifetime appointments. Contact your representatives, support groups like Alliance for Justice or Institute for Justice. Share this video, subscribe for more on reclaiming our rights. We the people deserve judges with integrity. Let's make it happen.